Good afternoon, everyone, and thank you for joining us. I'm Mark McAteer, I'm Managing Editor of Legal Business magazine, and I'm here to introduce today's webinar in association with OpenText, which is on deferred prosecution agreements 6 years on. We're going to look at the advantages and disadvantages of DPAs, the practicalities of seeking a corporate DPA, and the impact on key stakeholders. If at any point you would like to put any questions to our panel, please use the Q&A box on your screen. I will monitor this throughout and try and feed in those questions when I can. I'm delighted to say we have a panel of real experts to discuss some of the issues today, both from the vendor side from OpenText and from the end user side, for highly experienced legal practitioners from chambers and law firms. We are very fortunate to have them on our panel, and I would like to hand over now to Patrick Rappo, the Global Chair of Investigations and Compliance at DLA Piper, to lead the discussion. Patrick.
Many thanks, Mark, and many thanks for agreeing to host this and inviting us to come along. You've set the bar high by saying that you've got 4 experts on the line, so we're all slightly nervous about that great introduction. But as mentioned, for my part, I'll be sort of chairing the discussions. We're going to try and keep it as interactive as possible. As has been mentioned, please use the Q&A function beneath. The idea is that we go through a number of topics. We'll sort of introduce ourselves now. We'll then go through the sort of context of why DPAs were needed, which will be one section. Please send questions through before the end of that one, and then we can answer them sort of in sequence. And then the next is the advantages and disadvantages. So again, please ask questions in relation to the corporate DPA side of things and the practicalities of seeking one. And then we'll look at individuals. And then after that, we're kind of looking at next steps, what's down the pipeline. We've been told that we've only got an hour, so as a result, we'll have to briefly go through all of these things as quickly as possible. As outlined, I am a partner at DLA Piper, and am involved in the corporate crime group, albeit I represent individuals as well, and I'm global co-chair of our investigations group. Prior to that, I was the head of the bribery and corruption divisions, or joint head of the bribery and corruption divisions at the SFO, and was involved in the creation of DPAs way back in the day when they were just a glint in the eye of the then Solicitor General, Sir Edward Garnier, as he then was. So he gets made up to a lord, David Green gets made up to a knight, and Rappo moves across to DLA Piper. So I get the thin end of the wedge throughout. But anyway, that's me. I will hand over to Richard so that he can then introduce himself and his role.
Hi, I'm Richard Whittam. I'm a former First Senior Treasury Counsel Crime. My principal areas of practice are business and financial crime. Relative to this webinar, I led a team of 5 senior juniors for the SFO in the DPA against Rolls-Royce, and since then I've advised third parties in relation to the DPAs against Serco and G4S.
Neil, if you could introduce yourself.
Hello everyone, I'm Neil Hawes. Like Richard, I have practiced at the bar now for 31 years, and over that period of time, the last 25 or so, I have been involved in white collar fraud work. In the last few years in particular, and relevant to this, I represented directors in Sarclad, and I also represented a director in Guralp Systems, both of which, as people will know, were subject to DPAs, but I was in those eventual prosecutions. And I, like Richard, advise both individuals and corporates, actually. I'm presently representing an individual in G4S connected to these matters as well.
Thank you. And both of those speakers have failed to mention that they are moved across to matrix chambers relatively recently, and in Neil's case set up his new chambers, Crucible chambers, so he doesn't have quite as fancy a sign behind him advertising his new chambers, but I'm sure you'll read all about it on LinkedIn. And then if I can introduce you to Matt Cowie. I think you might be on mute, Matt.
Apologies. Yes, I'm a partner at Deferred, formerly colleague of Patrick at the SFO, we had many happy times together. I did some of the very early cases before the Bribery Act, the first corporate cases, and have recently been involved in the Airbus DPA. That's principally what I've been doing for the last 4 years. I do also represent individuals like all the other speakers, and I had a client in the Alstom case who was acquitted last year, for example. That's me.
It's a tough life, Matt. It's a tough life. And now, if we could also introduce Gareth from OpenText.
Thank you, Patrick, and good afternoon, everybody. It's Gareth Meachard. I'm a director here of the legal tech organisation OpenText, looking after Northern Europe, and looking forward to our conversation this afternoon, and where there is any requirement for maybe stronger and better integration or look of documentation in these processes, I may be able to assist the panel.
So really, it's over to me at this stage to sort of set the context as to why DPAs were needed in the first place and how that process came about and where it led to. And as Matt has mentioned already, in relation to the previous position prior to the introduction of DPAs, was that the SFO was at a real disadvantage on a number of tacks in terms of trying to get results against corporates. Number one, the law in relation to corporate criminal liability is very difficult to establish that corporate criminal liability, and the recent case of the SFO and Barclays Bank highlights that because it was decided in that case and shown clearly in that case that for a company to be liable in relation to a fraud, it must have either the full board or else an individual director who has complete responsibility for that area for which the fraudulent decision was made to be able to make the company liable. So that's a very high hurdle to overcome. That was changed somewhat with the Bribery Act, which enabled the corporates to be liable if there was a failure to prevent bribery taking place. However, the huge get out of jail card is having an adequate procedures defence, which is basically a complete carte blanche for new prosecutions able to be brought. And as such, there have been some difficulties in terms, again, of showing that there were inadequate procedures in place. But ultimately, in terms of settlement processes, if there was a criminal conviction in place, that would have huge ramifications for companies and would risk them not being able to apply for government contracts and be banned in terms of EU debarment mechanisms. So as such, we at the SFO were looking around to see what other tools, what other law changes could be brought in that would, one, facilitate companies being able to be found guilty sooner, or secondly, to be able to have an out-of-court settlement process that didn't involve a criminal conviction. And as a result, we looked towards the US and the Deferred Prosecution Agreement system there, which was essentially an out-of-court consent order, in order that an admission of some type was made, that an agreement to pay a financial penalty was made, and that improvements in terms of compliance processes were to take place. And that would defer a prosecution until the period of time over which the agreement lasted would elapse. And if all the conditions were met, the prosecution would be stayed and would never take place. That was an agreement largely between prosecutors and the company in question. And then the court, like civil recovery in the UK, would rubber stamp the consent order, the agreement, the deferred prosecution agreement. So that process was looked at to see if it could be brought over wholesale to the UK, but there was significant judicial opposition to that because judges didn't like the idea of prosecutors being able to reach cosy deals behind closed doors. And as Matt's mentioned already, being involved in some of those earlier cases, one of which was Innospec, which ended up going to court. It was a criminal prosecution, but comments made in that case indicated by Lord Justice Thomas that the court was not happy with the idea of corruption cases being dealt with via civil recovery settlements. So again, judicial opposition to civil recovery settlements and their desire for something to be open, transparent, and tested in court led effectively to the DPA system as created within the UK, which is effectively statutory, so it's not a common law process like the US system is. Secondly, it's only operational against companies and not individuals, which is the US process. And thirdly, it takes place generally in open court at the final stages and is fully tested by the judge at the preliminary private hearing. But beyond those changes, it's a largely similar process to the US system. And the idea behind it was to incentivize companies to identify wrongdoing, to come forward at an early stage, and to receive a significant discount. And as you've heard from those who were involved in the Rolls-Royce case, I was involved in the early part of the prosecution phase of that, and Richard's obviously involved in towards the latter stages of the process. But as can be seen from that, those cases, there were significant discounts applied for what's being termed as exceptional cooperation. And initially, the discounts given were to be in the region of 30%, so similar to a plea of guilty, but because of exceptional cooperation in more recent cases, such as Rolls-Royce and Airbus, discounts of up to 50% have in fact now been given. So there's a significant incentive to come forward and self-report. But at the same time, part of the idea behind them was that evidence would be given on who had actually conducted the criminality. And you will have seen from recent SFO guidance in this regard that the expectation is that companies produce evidence of who committed the wrongdoing and produce that material to the SFO in order, the assumption is, that action be taken against them. So that's the context of why they were needed, why they were created and came about in the first place. They've since taken some time to get off the ground, but now we've got a body of cases from which we can sort of pull together a number of strands and then try and apply them to the future as to next steps ultimately. But before we move on to looking into the future, if I can hand over at this stage to Richard first off and then Matt afterwards to discuss, as you say it, the advantages and disadvantages of the corporate DPA system.
Certainly from my point of view, the advantages are on the best side, but both for any company that has had some conduct, provided the conduct can be identified as being sufficiently egregious, and also the SFO. Why? Well, ordinarily, as Patrick said, DPAs are overseen by the court, and the court will usually want the company to keep trading. So, for example, in Sarclad, they didn't make any, the SFO didn't apply for any costs because they simply didn't want it to be too onerous to defeat the object of having the deferred prosecution agreement. There are, I suppose, three principal advantages. Speed. I'm rather in the same boat as Matt. I was tied up with Rolls-Royce for 4 years, and he was tied up for 4 years in dealing with Airbus. But that is relatively quick. If you think, and Neil will be able to tell us about individuals in G4S, but they're not due to be tried until January 2022. If Rolls-Royce had been tried as a corporate, would still certainly be going now and probably until I retire. Another real advantage is certainty. You know what you're signing up to. It's been part of an agreement, that you've negotiated it. There's a draft indictment and you've had input into the penalty. And costs obviously flow from the two above. It's far cheaper to prepare for a deferred prosecution agreement, although there's a huge internal investigative cost which can be assisted by how you deal with the data. Matt, it was the same as we were in Rolls-Royce, 30+ million documents to look at. You simply can't read everything. Even the Court of Appeal accepts in the disclosure cases that the kind of material we're now looking at, you simply can't read everything. You've got to have some assistance to look at it. But it is still far, far cheaper than having a trial. Equally, because of those uncertainties if there's a trial, the reason for having the first hearing in private is in case the court rejects it. It's also away from the market's eye. There needs to be rather an elaborate process that you don't want whichever judge is dealing with it to tell you they're going to approve it while the markets are still open, because of course corporates have a duty to report.
Just on that point there about the court rejecting it, and bearing in mind the comments which were made by Leveson in relation to Rolls-Royce, do you think there are any circumstances in which a court is actually going to reject a DPA, bearing in mind that what was said about Rolls-Royce was that it was over 3 decades, over 5 jurisdictions, and possibly the worst and most egregious type of bribery, and that the judge could see no other alternative except for a prosecution until and the exceptional cooperation arose. So in what circumstances do you see there being a prospect that a prosecution would come forward?
I think it's very unlikely if it's been conducted properly. So the SFO, the director, shouldn't be putting before the court something that shouldn't ultimately get agreement. There may be disagreement as to penalty, sanction, disgorgement of profit and the like. What really was wanted by Leveson was individuals being held to be liable and to be individual prosecutions. Some of us were rather surprised when the director of the SFO at the white collar crime meeting in October suggested she was rather keen to have prosecuted the individuals in Rolls-Royce, but had been prevented from doing so because they'd all died. That came, she mightn't have used the word all, but she certainly said they died. It came as rather a surprise to me. I only dealt with the corporate side of it, but the juniors that I was leading carried on with the individuals. And certainly when I inquired of one of them, who I won't name, afterwards, whether that had been a reason that they were aware of that the individuals hadn't been prosecuted, that the response was, had that been the position, their advice would have been somewhat shorter and an awful lot cheaper. So I think there is that tension between corporate liability. We'll come back to that and the Law Commission and things like that. Yeah. But the difficulty is with prosecuting a corporate. What can you do but fine it? Therefore, this is a far swifter way to get to that resolution. And so if you've been through the negotiation process, so having engaged the SFO, you really should get it through a court, provided the penalties at the right place and disgorgements at the right place. It might be a bumpy ride, but you should have addressed all those issues. We don't know, of course, whether any have been rejected, and that's the whole purpose about having a private hearing.
And Matt, from your point of view, what's your thoughts in relation to the advantages and disadvantages, apart from the obvious advantage of bringing in Deferred and Mr. Matthew Cowie to deal with the matter?
Well, I think that's been very well covered by both yourself and by Richard. You know, corporates want finality and speed. And in countries like the UK and in France, prior to CGIPS, for example, you got neither. And of course, there's the problem of having a conviction itself. I think one thing that is slightly overlooked in the Rolls-Royce judgment is, I think, the effect that the evidence about loss of order book that was put before Leveson in Rolls-Royce was substantial. And I think everybody talks about their self-reporting, but in reality, I think the judge was very concerned about putting out of business, you know, a British institution, you know, a household name, and of course, an employer of up to 50,000 people. So I think that was quite an important consideration in his judgment vis-a-vis prosecution as opposed to a DPA. I think without that, maybe there could have been a prosecution, but and again, the same perhaps with Airbus as well. The numbers are so large that a sentence like that plus then COVID could well have destroyed all value in the company. But I wanted to just mention, I totally agreed with your insights in opening, Patrick, because back in the day when we were colleagues at SFO, we neither had good law nor did we have the procedural tools to really bring corporates to book. And Innispec really was a game changer in that respect, because Lord Justice Thomas took the case on and was behind the scenes in driving through the DPA solution. Other people had hands on it as well, of course, but he could see that this was coming, that that corruption involves more than one enforcement authority, more than often. And so how do you deal with the division of that if you don't have any mechanism to do so before you reach court? And fortunately, we have come to good arrangements more recently. For example, the no piling on policy with the US authorities, so that we don't have that kind of interagency jockeying for cases where there is obvious overlap between the facts, where both or more than one or more than two mature enforcement authorities could in fact claim jurisdiction over part of the conduct. And that then brings you to the question, I think, not just of, are DPAs a good thing, but, are our DPAs a good thing? And once you've been involved in a few cases where you're working with other authorities, you notice how more nimble they are at being able to come to a settlement. I mean, who would have thought the French, within 18 months of introducing CGIPs, had brought 6 matters, household names, some substantial French banks, levied very high fines, and done so at breakneck speed, far better than the way in which the Bribery Act was enforced in the early 2000s and 10s. And so maybe there's a sort of an additional little question here when you're dealing with concurrent jurisdiction and working with other enforcement authorities of how good is our system? Does it actually really help us come to resolution as quickly as other nations can do it, or are we a drag on these types of cases?
I think you've introduced an interesting point there in terms of the lack of nimbleness of the UK system, and you and both Richard have mentioned about the speed at which the corporate DPA was reached, which is absolutely correct. In both cases they were a short number of years, whereas you can compare that with the GPT investigation, which I was involved with at the SFO in 2010, which has just been charged this year, 10 years later, and still hasn't concluded because it's just starting the charging process. But in terms of individuals, and I don't expect you to tell us hot off the press what's happening with individuals in the Airbus case, but presumably one of the disadvantages is that if there are to be subsequent trials of individuals, the corporate is still required to assist in an ongoing way with the SFO, and therefore the DPA won't be the end of the process. So it'll be the end of the bulk of the process. It'll be the end of the bulk of those investigative charges, which you and Richard will be racking up on the company's behalf. But that still won't be the end of you and Richard. You'll still be there for those additional bits and pieces. Do you see that as being something problematic, or do you think that that is considerably more manageable than a costly and lengthy and very damaging trial process?
No, not at all. I think we've seen, I think, a number of the enforcement authorities taking very pragmatic views about the length of corporate investigations recently. I mean, Airbus was a substantial case, and it was dealt with, I think, within a reasonable time. It could have taken much longer. There could have been more investigation, and indeed the Americans agreed to post-settlement investigations to be conducted without there being any further liability. So, you know, there's an acceptance that, you know, there's only so much you can do within a certain amount of time, and that there's a kind of balance to be drawn here about encouraging corporates to come forward, especially the biggest corporates, where they can expect you know, justice within a reasonable time.
And in terms of some of the practicalities here, if we turn to look at that, so we've had a great overview of the, you know, the advantages of the system. But Richard, from your point of view of looking at it from the your involvement in relation to the Rolls-Royce side of things, can you give us some examples of the details of the practicalities of what a corporate need to be doing to go to the SFO seeking a DPA?
Certainly from where I am now and having seen the development of them, it is knowing as best you can what's in the box that you're putting your hand into and what you're going to let the SFO look at. So Rolls-Royce, their exceptional cooperation, was really turning over all the internal interviews, waiving legal privilege as far as they were concerned, obviously not their own litigation privilege as far as the DPA was concerned, and really handing everything over. Now that was because I think they had a reasonable idea what had happened, and it was a little bit of time ago, and everything had changed at Rolls-Royce, which is, along with all the other exceptional cooperation and things like that, how it came into being. But if you're a bit smaller, you really do need to know what it is you might hand over. I know there's a debate at the moment as to whether internal interviews should be recorded, because of course you're then handing everything over rather than a summary if you have it, and that element of waiving privilege. And so I think there are great practical considerations when things are so big.
Well, just before we consider the point of interviews, in terms of that, and again, this is something which you know, Gareth and the OpenText team might be able to comment on as well. But just in terms of the tools which were used in the Rolls-Royce side of things to look at those mass of documents, be it on the prosecution side or the defence side. Predictive coding and the impact of that. What's your views in relation to its benefits and its sort of cost benefit analysis in relation to it?
It couldn't have been done without it. Just too much material, and you can hive things down to find out what. Well, you've got a better chance of not missing things. I'm not going to say it's perfect, but it's just wholly impractical to do it without it. And you can fine tune what you are looking at. Which just wouldn't have been achievable in the timescale, given the scale. So vital, as far as I am concerned, for those kind of, you can refine the search as it goes on. I mean, the strange thing about Rolls-Royce, and Matt will be able to tell us about Airbus, an awful lot of Rolls-Royce, because it was so old, were paper documents that had been scanned. Whereas the approach now, and I think it's a phrase I quite like from Brian Levison in Richard's R&R and others, the practice note about electronic disclosure, when he said that the problem of vast quantities of electronic documents has, in a sense, been created by technology. In turn, appropriate use must be made of technology to address the problem and solve it.
I think everything has changed enormously. One just has to look at the Attorney General's guidance in relation to disclosure, and frankly, it hasn't hit the big fraud cases as much. But when you simply look around who's on this call, we probably all have a mobile phone, if not two of them, and then we have a device directly in front of us as well. So between us, who would be a very small business if we were a business, we have got just hundreds of thousands of documents and all of our equipment. Cost-wise, Matt, what was your view in relation to the cost benefit of using the predictive coding on your case?
Well, I was going to say straight away, I agree with Richard's comments. You cannot look at everything. 30 million documents would take a lot of people many years to read. And, you inevitably, when you do a big case, and in the end, we had more than 800 custodians in total, which was, for different purposes, of course, not just for the investigation, but, to remediate the company, to find out what people were doing, to defend arbitrations, to obtain export credit arrangements for customers safely, without there being a risk of corruption. And so when you're reviewing for multiple purposes, one, predictive coding is useful. Two, you don't want to be looking at the same document more than once. I mean, I'm very pleased with the outcome in our case, because we didn't actually know about the SFO's use of predictive coding in Rolls-Royce when we had to make the choice to go down that route in Airbus, and we just took an educated guess that that we could do that, and in fact we looked at 3 million documents out of the 30 million. But what I can say is that obviously the authorities have control over the total universe of documents. They have their own leads, they have their own sources of information that themselves or can generate them, and so they can really interrogate whether you are using the technology appropriately and effectively. And not one document in the UK DPA was produced by the prosecution first, without us producing it to them in our interim reports as we went along in the case. And so for me, the benefits are that you get to the good stuff fast. And of course, you can also, to some extent, grade how good the good stuff is, and that allows you to move ahead in your investigation, at the beginning quite quickly if you know what all the issues are.
No, it's very helpful. Thank you. And just sticking with you, Matt, in terms of any other sort of practical takeaways of sort of approaching the SFO, we've heard from Richard saying, know the universe of stuff, get to understand it. Any other practical takeaways you'd like the the audience to have from your experiences?
Yeah, I mean, I'll do something very simple, which is I always think that you're either in or you're out, and I think some firms in the past have kind of floundered or been caught out by being sort of 1 foot in, 1 foot out. If you decide to self-report, you need to have scoped how bad it is. You need to know and have socialized your client to understand that this might go from this subject to another continent, to another business unit, or whatever. You've got to have worked that out first. SFO might not like that, although there are ways in which you can navigate with the SFO the kind of scoping of your own investigation. But once you're in, you're in, and there's no point messing around and trying to conceal things that are harmful to you. You have to bring out all of the nasties and put them on the table and try to negotiate the best settlement you can.
Neil, that's probably a good point to bring you in, just in terms of the G4S and Serco side of things, because there was a view potentially afoot that one of the two might have treated the SFO sort of less favourably and less openly, and therefore is at greater risk of prosecution. And again, I don't ask you to comment on that, but just in terms of what Matt's been outlining there, do you think actually DPAs are now going to be so ubiquitous that actually you don't have a huge risk of a prosecution, or do you think, like Matt says, you really do need to show everything and show it early to get the maximum benefit out of it?
I think as time has developed with them, I mean, I can talk in the historical sense, which is perhaps more safer given present proceedings, but in the historical sense, for example, what was interesting to me, having represented an individual in the SARCLAD case and eventually having seen the work that the corporate advisors did to get that DPA, I do sense that the SFO are almost taking now, in this day and age, as opposed to then, some 6 years ago, a rather more sort of CMA approach to it. So in other words, they were receptive to an anonymous place marker in SARCLAD from a very early stage, where although they had initially scoped, as Matthew rightly says, some element of infraction by individuals, they didn't quite know the full extent of it. But they were prepared to take an anonymous marker at that stage. And then within 6 weeks, the corporate advisors came back and had a more fullish report. Now, there are dangers, obviously, in that, as Richard has pointed out. It didn't, and that, in fact, in that case, know the full extent of the difficulties that the corporate faced. But that is what, frankly, full cooperation looks like. And I agree with Matthew to that extent. If you are advising the corporate, and I do both, although I'm going to talk about individuals in particular, if you're advising the corporate, you are going down that route for self-reporting, I mean, quite frankly, you need to be providing exceptional cooperation to the extent of disclosing the very best information that you possibly can, of course, observing anything you want to retain as being privileged if a client so chooses. Although I've had one or two corporates in quite recent times where they're even prepared to consider a waiver of privilege if the need arose.
Well, also, I mean, sometimes on the privilege point, you know, especially in multi-jurisdictional cases, you know, the privilege issue drops to the lowest common denominator, and you end up in that position. And so, you know, if you're lucky enough just to have a UK case, then it's you know, you have that problem, but it's quite often you don't have that problem. It's relieved. You're relieved of having to argue it. So yes.
But your point about you know, are we in a situation where do the corporates really risk prosecution? I mean, as others have observed, we don't know whether people have gone to the court and the court has refused a DPA in the past, but the converse we do know. There's not exactly a plethora of prosecutions for companies. And so as a consequence of that, one can draw the inference both from the information and indeed, I can't say too much, but the stuff that we saw in the two cases that I was involved in, both corporates were, shall we say, questioned quite seriously in the interim hearings before the final public hearing, as we saw that disclosure eventually. But one of the criticisms that I would have is the degree of examination that the court really put the SFO and the parties under in those cases before the DPAs were agreed. And I think that is one of the weaknesses of the DPA regime. I mean, you guys have been on the corporates, and Richard particularly on the corporate side, doing that. But from the individual's perspective, you know, it's one of the things that we argued in the SARCLAD case. You've got, not quite, and I don't mean this in the literal sense, because clearly when you are representing the SFO, you're acquitting a different responsibility and duty. But it is interesting in a DPA situation that it is unusual in our jurisdiction that you are going to court where both parties want effectively by that stage the same outcome. And there is an argument, maybe more academic than anything else, there is an argument that it does not suspend, but certainly blunt the adversarial process a little as between the respective parties.
But having been somebody that was involved in the creation of these and been involved with them since, what's wrong with that? Because unless you get to the Tesco scenario whereby an individual is named and shamed, which frankly was a ludicrous decision, come what may, but put that to one side for a second. But unless that has actually happened, what is the difficulty with two parties agreeing to something? It happens every day in consent orders in the civil courts. So what is the difference? The only query would be if somebody is named and shamed, or if the investigation hasn't been done properly. But when you have advisors like Matt and myself on one side, or the SFO on the other side, it's in everybody's interest to investigate it properly, because this is to be the one-stop shop that covers everything, wraps it all up like a nuclear bomb, covers it and then buries it, for forever. So what is the difficulty with that?
The difficulty with it is, and Tesco's wasn't the only example. My client was, although it was redacted pre the trial actually, but the unredacted judgment in Sarklad names all of those clients as well. I think what we've got actually is an interesting movement in the jurisprudence over time. And it's very interesting when one looks at the judgments now that we're into a more anonymized or no mention of individuals whatsoever compared to those early iterations of the DPAs.
Well, bizarrely, the US system has always been, you don't name.
Exactly. But I think
Matthew and I have been involved in the Dadalay case and Alcoa, which, the US effectively settled the day after he was released from the UK court, and, they didn't name him at all. Even though
you ask what the difficulty with it is, Patrick, and I one of the things that I was thinking of saying, or I was going to address about in terms of individuals, is the best analogy that I can sort of come up with, although it's a poor analogy, when talking about what's wrong with that position of two parties coming to that agreement, is a little bit like it's a wedding, except for the individual, it's a surprise wedding. You happen to be the groom, yet everyone is talking about the arrangements for the wedding behind your back. And history so far has demonstrated that where the SFO has the appetite for the prosecution, or indeed the capacity to prosecute individuals arising out of DPAs, the analysis of the evidence, which is the bedrock for the DPA, hasn't supported a conviction.
Again,
some of that arises from
I've a view about that, because we've only really had 2 or 3 of those instances, and there may have been some particular reasons for some of them. There have been convictions, on the basis of pleas under the old laws, that I brought when I was a prosecutor. I think, it's probably a little bit, we don't have enough of a control group yet to be definitive.
But out of the DPAs, Matthew, there hasn't been any conviction, has there?
Yeah, I just don't think I don't think we've had enough numbers to be able to really tell yet. There are some specific circumstances, at least in some of those cases, which lended themselves to acquittals.
And I think jury trials always have that risk in any event, because and often frauds or bribery and corruption come down to your intention. Did you have that dishonest intention? And that's often a difficult thing to find beyond reasonable doubt against an individual. But Richard, I think you were looking to say something there.
It was really. Do you think that there are 2 points really? That the first one is the American approach. So respondeat superior. The company's liable for acts. There's a very slight margin of people acting on their behalf. But the reality is, if people are committing offences, it hasn't slowed down DPAs or NPAs in the States. It's on exactly the same level this year as it was last year, despite COVID and everything else. So I think they're 20 odd plus already this year. So it doesn't stop there being DPAs, despite the fact that it's very easy to prosecute a company. But doesn't that arguably make it easier to prosecute an individual if you don't have to go through this fuss of identifying who it is who's bound the company at what level, as in Barclays, focusing it more acutely? You can just get on with, look, some people on their watch with the company committing these offences, company cough up, and if we've got sufficient evidence against individuals, we'll go after them and can do it far more quickly. We've not been slowed down, as Matt, I think, was hinting at, by the judicial oversight. It's got to be a cumbersome system because we've got to get it all sorted out before you go near a court. Whereas if you are agreeing with less oversight, it can happen more quickly. But also just built into that, I think the SFO are so targeted on results. I was really taken with, and I must admit against, but taken with Lisa Rossofsky's comments just in October when they published that chapter from its internal operation handbook, when she stated DPAs require the company to admit the misconduct, which, as Patrick's pointed out, is precisely what the underlying legislation in the code does not say. They do not have to make an admission, and that's why certainly in Rolls-Royce we didn't identify any individuals. Of course, you could perhaps with enough knowledge work out who they were, but you don't name them. But the company is accepting that you've got sufficiently far that you are going to be able to prove something against the company. But we get all tied up with that.
Within a reasonable period of time, which was brought in specifically because at the time we didn't want companies to have to make an admission because it could be used against them in the civil process. And as a result, we had the threshold test, which is willing to accept that there was wrongdoing of some kind, but it's not a full admission made on behalf of the company.
And particularly important, as you indicated from the outset, any corporate involved in public procurement, if you have a conviction, statutory bar, if you're making an admission, so if you're making an admission in the statement of facts or in the DPA, certainly in this jurisdiction, but almost everywhere else, a discretionary bar is coming your way. So that's, as I understand, the whole point is everyone understands it's gone wrong. You're only going to get one if you've sorted out how you run your business now. Rolls-Royce have completely changed, etc. Well, what's the problem? You can only find them, and at least everybody can keep going, and you only get one chance at it.
So Neil, just on that, the individual's point, you've mentioned, some of the impacts upon them, and any sort of further thoughts as to the impacts on individuals? We've got the sort of naming and shaming. We've got their sort of shotgun wedding, which they don't necessarily want to do, but they've got the gun to their head. Anything else beyond that you think's a good takeaway?
I think one of the key things that I've experienced in the two that I've done, and third ongoing, is actually the DPA process, for all the reasons that everyone's discussed. One can see the speed and the utility for the corporate, etc., etc. But it does have an impact on the way in which the Serious Fraud Office tends to prosecute the individuals within the court, and by which I mean, but both in, and this is, there are matters of record, so I can say this, both in SARCLAD and in Guralp Systems. The SFO had a very particular viewpoint of certain elements of evidence in respect of each of those cases, in respect of various defendants. And it wasn't clear from the face of the evidence why they took that view. After much litigation about it, actually, it was clear that the SFO took that view because they had adopted the analysis that had been taken by the corporate advisors leading up to the DPA. And there was, as you will know, quite a lot of correspondence and exchange in terms of the cooperation. The difficulty with it was that the analysis in both cases actually was erroneous to the extent, not deliberately, but to the extent that the advisors, with one eye on the corporate's interests, doing a perfectly appropriate job, and putting forward the corporate's interests as they were required to do, hadn't had regard to certain other evidence, which the individuals concerned had access to, were aware of. There was no question it wasn't in existence at the time, and can give greater context to. And so you found that the SFO took a rather unusual position in both cases, but because of the way the evidence had been collected, presented, and it had effectively tinged their analysis of the case against the individuals, the defense in those cases had to then respectively sort of inch their way into a position in the litigation in front of the jury to try to persuade the jury, but certainly ultimately in one of those cases, to end and change the SFO's case actually in respect of that evidence halfway through, which was both damaging for the SFO, of course, but it was directly impacted on, and I make no impropriety about that. It was by the nature of the way in which it was presented and the lack of thought or lack of review around that whole area. So
but is that not an issue though in relation to simply the SFO's analysis as opposed to a problem with DPAs inherently?
Yeah, exactly. So what I was going to say,
the DPA is just a statement of facts, and that statement of facts is only as good as the effort that's put into it, either from the company or most likely on the analysis of the SFO as well.
I agree with that, but I think the takeaway from it was, and it was a sort of lesson learned from it, is that the experience, I'm afraid to say, in one of those cases was, because the corporate has delivered the self-report, it has done a very good job on the self-report. Certainly in one of those cases, there was evidence, and indeed one very senior member of the then SFO was saying, well, how can you take issue with this because the corporate has admitted it? And there was this assumption that there wasn't, as you rightly say, that analysis around by the office because of the way it had been delivered. And so I'm sorry to say that in that particular instance, one didn't get a picture that they'd looked at the overall package of the evidence in that particular chapter of the case.
Well, I see that we're now moving into the sort of last 10 minutes or so. So keen to move on to sort of next steps and where we see sort of DPAs going next. And I kind of open it up to the audience because everybody's been very quiet in the Q&A. So please think through any sort of additional questions that you have, and then we can deal with those in the next 10 minutes and drop them into the Q&A box at the bottom. But just in terms of looking down the pipeline as to what we see as happening next, if I can just sort of start the ball rolling in relation to that by saying that the recent case, which has come out, the Menzies subsidiary and the airline case, the much smaller DPA, I think is indicative that the SFO is going to be concentrating on DPAs on bribery matters because it's much easier to establish corporate criminal liability, unlike the fiascos that there have been with Tesco's and with Barclays and being unable to establish corporate criminal liability there. So concentration on DPAs with bribery, and secondly, concentration of DPAs on any level of case. So not just the big cases, but being what it was envisaged for in the first place, being the tool of first resort. So that's where I open it up. Do you agree with that view? And I open this up to Matt, Richard, and Neil equally to see if there's any contrary view to that.
A couple of observations, Patrick, about where I think things are going right now and where things should have gone 10 years ago, really, when we started with the Bribery Act and even before, because I'm pretty sure in your cases, you saw oppositional and competitor information about bribery, at competitors. And it didn't seem to me that SFO, properly, looked at that and thought, oh, here's an opportunity to make another case. And that's something that the DOJ have been doing very successfully for years in industry sweeps.
But do you think that's happening? Sorry to cut across you with the kind of line of cases at the minute with Rolls-Royce and
exactly. I mean, Rolls-Royce,
Airbus, and then the Bombardier announcement, which has come out, and obviously Menzies is an airline case as well. So do you think that is beginning to follow that US trend of focusing on an industry and the sort of golden goose that's laying these multiple eggs?
Yes, I think that's right. And, you've almost sort of given the kind of, there's Panasonic as well, of course, they were done in the US for the televisions that are in the seats of aircraft. And And so you've got the aviation industry, but then you've got aviation that moves into the military, and then you've got helicopters, and then you've got various joint ventures on other related aspects of those industries. And with increasing cooperation between developed regulators, there's more than enough to go around. And so yes, I would say number one, the industry sweep is clearly on. Now in the UK, everybody gets that. These are easier wins when you've got half the evidence in a competitor's documents. Secondly, and I think going with that, one huge change has been the way in which the US is now playing with European authorities. There isn't that kind of jockeying that there was in the early years, in the 2000s when we first.
I was going to mention BAE, but I thought that might make you break out into a cold sweat, as it was your case at the time.
A lot of my cases made me break out in cold sweat, but then again, they were amongst the first, and they all had some flaws and some good parts. But I do think that now the no piling on policy is being properly adhered to. I don't think the people that are at the DOJ are quite as good as, the caliber is not as good, the numbers are down, but nonetheless, they're still playing nicely with more aggressive European authorities. And I think that, in the past, the US would look to fall out with, a particular nation over one case, a big case, but maybe now they have 30 cases together, and so that's not going to happen. There's going to be a lot more cooperation and horse trading, in all of these matters. And so I think, yes, I think we can look forward to plenty more multi-jurisdictional cases involving mature authorities.
Yeah, no, I think Petrobras and Airbus are great examples of that. French, US, UK, and sort of Brazilian, US and European. Although obviously the question has been that the US has been focusing, and the view is that it's been focusing on sort of foreign competitor companies and taking action against them in terms of FCPA enforcement. Any views, Matt, as to whether you think China might be on the rise with their actions against GSK, with their involvement in relation to Alstom and so on? Do you think they might start up a similar type process in the future where they take action against foreign companies, and bearing in mind they don't have a settlement process there and don't abide by legal professional privilege at all and have very wide state secrets law, that this could be a game changer if that were ever to take off?
Well, I think the FCPA has always been enforced to some extent quite politically. And that, when you mention China, that becomes very interesting. As to the South American cases, I think it's definitely political, but it's more to do with good governance, I would have thought. I think FCPA has been used as a tool to improve governance in those areas. But let's just strike off France for a moment, because I know for a fact that the DOJ and the Parquet are getting on famously well, and they have plenty of cases together. And having Sapin II in the way, I think there's a real balance of power and now a respect really for French justice, where there wasn't that kind of respect for French justice certainly prior to Airbus. Our biggest challenge in Airbus wasn't persuading the SFO that we were doing a good lawyer-led investigation. It was impressing the French police, who view all lawyers as liars, who would lie for a living, and would never, dime up their clients, to the authorities. But once you win their trust, and once they saw how fast the investigations can go, in comparison to these kind of 18th century approaches to justice, such as the juge d'instruction and their processes. They can see that they can achieve big results, big fines, and do it faster than the UK.
Well, that's fantastically helpful. I know that we haven't heard from Richard and Neil in relation to this, but probably over to you just for a couple of closing thoughts from you, because I see that we're 1 minute to go. So the final countdown, and over to you, Richard, as we haven't heard from you in a while.
They're here to stay. Just like in America, they're going to stay. There's going to be some change in legislation, whether it be more failure to prevent offences or whether the Law Commission looking at corporate criminal liability. It's argued on both sides, but it is a bit weird if you step back from it and think of corporates now living in the cloud, can move from one jurisdiction to another overnight, and we depend on a bit of common law that was before we even had emails. So
I'm not sure we're going to hear anything from the Law Commission for many years. That can has been kicked well and truly down the line. Neil, anything further from you in terms of closing?
No, I agree. They are here to stay. I agree with Matt. The idea that the anti-piling on policy, I think, will have a dramatic effect. I'm interested in the sense that I think over the last 10 years, the DOJ's attitude, I suspect, has changed because we now have the tools, as do other European parties, have the tools to act in a way in which they've been acting for many years. So they are here to stay. They are creating a sort of body of jurisprudence which is assisting in corporate governance, which is obviously one of the SFO's objectives, but also most saliently of all, and it's a topic or a fact that someone told me the other day, which is quite stark as to why they are here to stay. 1 year of a DPA has acquired more monies in disgorgement and fines than the entire life of the Proceeds of Crimes Act. And that is why it's here to stay.
And I think it's international as well. And other countries, Singapore bringing it in, Australia bringing them in, that they are just moving across the globe. And bearing in mind the rate of technology, things like predictive coding will absolutely need to be used to check what is happening within a company, and also the improvements in compliance and policies and procedures generally, and the incentives to come forward and to assist the authorities all indicate not only that they're here to stay, but they're going to become much more international, and that will be much more dependent on predictive coding, etc., to review documents both in advance of any whistleblower or after any whistleblowers come forward. But thank you all very much for that. And I hand back to our OpenText hosts for any concluding comments from them.
Thank you very much.
Thank you all for your comments over the session there. Very insightful. Very much see that, as you conclude, it looks like DPAs are here to stay. And one thing that I'd just like to say from an OpenText perspective is something you brought up sort of mid of the session. What was that 30 million documents that were needed for review, and the enormity of that task, and for the panel and for the people listening in. If you take an average of 40 to 60 documents an hour for somebody to run their eyes over, you were talking about 750,000, 750,000 hours of effort would have been required to look at those documents. From De Silvermore, like sort of almost 10 years ago, Pyro here in UK courts, predictive coding is available to the corporates to use to reduce that burden. And I don't like to look at that as saying we're not going to review 30 million documents. I like to think that of that, 80 to 90% of those documents will be reviewed by a machine on your behalf. And as you rightly say, technology caused the volume of this problem. Technology needs to help you resolve that. And if you're looking at billing hours and with the distinguished panel in front of me, I'm sure your hourly rate is slightly different to mine own, and those within our services organization.
Ours is fantastically cheap. We're a snip in comparison.
But if we could halve your rate or even quarter your rate at 750,000 hours, that's a distinctive line item with any consideration of that process. And if we can assist our corporate clients to look at that data earlier, look at it faster, get meaningful insight way before you start talking to even maybe the likes of yourselves or the SFO to understand that position, and then using the review and that predictive coding later in that process. Hopefully, the likes of ourselves at OpenText can add some value into the DPAs as you engage them with your clients. But thank you for your time here this afternoon. It's been extremely insightful and hopefully useful to our delegates.
No, well, thank you for hosting us.
Thank you.
Thank you.
Thank you, Gareth.
Bye-bye.
Thank you, Patrick. Thank you, Matthew. Thank you, Neil.
Thank you.
And thank you, Richard. Please, thank you all for taking part today. And if any of you have any further questions on this topic, please feel free to email them through. My email address is mark.mcateer@legalbusiness.co.uk, so I can field any questions that come through after the fact. But for now, thank you all very much for taking part. It's been a very interesting session, and I don't need to take back my comment at the start about having some very serious legal experts on this topic, and it was very enjoyable. Thank you.
Thanks a lot, everybody. Bye-bye.
Thank you.
Thanks. Bye.
Bye.